and we will begin in a second. All right, so once again, welcome. Before we go into the topic tonight, I want to just give you a little information about how the seminar is going to run this night in case it's your first time here. The seminar is intended to be 45 minutes. Sometimes it's a little longer, sometimes it's a little shorter. I never know exactly how long things are going to go until I'm actually in the middle of it. Do my best to keep it to 45 minutes because I know everybody has other schedules to keep to. This is a one-way communication, you may have noticed, so you hopefully can hear me, but I cannot hear you. If you are having a problem hearing me or seeing the display, which should say today's webinar, just type a note into where it says type question here on the right side of your control panel so I can make sure that everybody is in and ready to go before I move forward. I'm not seeing any notes, so I'm going to assume everybody can see and hear me. I'm going to be closing my panel, so if something happens during the webinar, it may be difficult for me to pick up any technical difficulties, but I'll do my best to make sure of it. With regard to questions too, I will not be taking questions during the webinar, but I will address all of them afterwards. I usually encourage everybody to type your questions into your question bar, which is again on the bottom, towards the bottom of the right side of your panel. So that way you don't forget it while we move on to other topics, and that way I will get to it afterwards. I'll stay as long as it takes for us to get through all of the questions that are posed. Next, let me give you a little background about myself and my office in case you haven't worked with me in the past. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I've been practicing law now for about 20 years. I'm licensed in both New Jersey and Pennsylvania state bars, as well as the federal 3rd District. I started my legal career working as a law clerk for Judge Austin in the Superior Court of Bergen County. Then I went to Kessler & Associates. I did complex commercial litigation for a couple of years, found that I liked complex litigation but not representing companies and corporations, so I went into my private practice in 2001, concentrating in divorce, family law, and estate planning, which is what my concentration is today. The Micklin Law Group itself also concentrates in those areas, so I handle more of the complex and high conflict cases. As far as some of my background, these are some awards for 2014. It's a little outdated. For 2015, I received either awards or recognitions from AVO, Global Directory of Who's Who, National Association of Distinguished Counsel, and the American Institute of Family Law Attorneys. I say this not because I want to try to boast my accomplishments, but I always say to people, you don't know if you have had a good lawyer until afterwards in many cases, so it's important you know who you're dealing with. If you're going to be sitting with me for 45 minutes, it's good that you know, at least I'm aware of what I'm talking about. So let's jump right into child support. The best place to start is with the child support guidelines, which is the basic fundamentals of all of the child support calculations and issues that we're going to talk about. The guidelines apply to parties with a combined net income of greater than $170 per week and less than $3,600 per week. What that means is basically the highest that it goes up to is $187,000 combined net income. Now, the guidelines themselves are presumed to be the accurate reflection of child support. It works on the combined income of both parents and works to calculate based on the combined income, which would represent the household income of an intact family if the two parties live together, which is the basic premise of the combined income calculation of the guidelines. The belief, theoretically, in the child support, in devising a guideline that worked on combined incomes, is that there are certain costs associated to supporting a child or children, and that those costs depend on the lifestyle that the parties would have shared if they were together, or that they do live in separate households. So basically, the more income, the more costs that you're going to have, because the better lifestyle you're presumed to want to provide for your children. So they work on a proportionate scale of income, and the higher the income, the higher the child support payments will be. Simply put, that is, at least. Like I said, it goes on a combined income of $187,000 net to after tax. In many areas, it's not actually a very high number. The guidelines were created back, I think, in the 70s, and there really haven't been many adjustments to the basic premises that they're founded upon. So in a lot of cases, they don't actually reflect current guidelines, current lifestyles, and we'll talk about why and how you adjust for that in the child support guidelines. There are ways around that. In the event you have a case that is a combined income with greater than $187,000, you then have what's called a high income addition. And that means on top of the maximum award of child support that would be received under the guidelines, you then have to go through the custody factors as if you were having a custody dispute to determine how much additional child support should be paid by the paying or obligor, the non-custodial parent. Basically, like I said, you go through the custody factors and you would have to have what's called a plenary trial where the court would actually go step by step into the specific lifestyle that you both parents are providing and determine how much additional child support should be ordered to account for that excess income or that increased lifestyle. So in a sense, the guidelines theoretically are intended to represent the basic needs of a child. The case that I cite here just is one that kind of expounded upon the reasons and what would be included theoretically. Again, for guidelines, we'll look more closely at it. But this case basically talked about basic necessities, and that basic necessities are going to vary from case to case. Everybody's family is going to be different. Everybody's lifestyle needs are going to be different. I think with the increase in blended families and obviously the higher cost of living, there are going to be new issues that are facing parents and families in child support issues that may not have been contemplated when the guidelines were created. So we need to have a basic understanding of what they were intended to cover. And basically, this is saying that anything that's reasonably necessary for the proper and suitable maintenance of the child. And we'll get into more thoroughly what that really means and how that's actually calculated. But first, let's look at what is included in the child support guidelines. First, let's obviously your basics: housing, food, clothing, transportation, entertainment, unreimbursed medical. These are basic. I won't spend a lot of time going over, except for unreimbursed health care. A few things that you want to take note with regard to that. First of all, it's $250 per year per child. And a lot of custodial parents miss this point, that it's per child and per year. Also important to realize that there can be a very broad definition of what is considered uncovered health care. I always say to my clients, you should look at things like not only co-pays and medical or medical bills, medicines, prescriptions, but also things like vitamins and healthcare supplements. You may have a child who has special food allergies that maybe you're buying food and you think it's food, but it actually has a medical purpose in some sense. So it's just, you want to look to have a broader understanding as to what would be covered in the unreimbursed medical, because I think, treatment of children has drastically changed again since the guidelines were created. Additionally, there are a lot of miscellaneous items that are factored into the guidelines: personal care products, books and school supplies, contributions, insurance, finance charges. This is just to give you some kind of basic premise of what they looked at when they created the guidelines. And in essence, what they did and what they still are supposed to represent is all of the costs that a family or a parent incurs in raising a child. And they looked at fixed, variable, and controlled costs, which are always going to be factored into the lifestyle. So you have fixed costs, which could be things like housing or mortgage payments, insurance payments, utilities. Even though these will from time to time vary, they're generally considered relatively stable, so they're considered fixed. Variable costs will be things that will change over time, like food, clothing, medical bills. And then there's controlled costs, which are a bit of a blend of both. They vary because they're not constant, but they don't usually vary while you're incurring them, like extracurricular costs or educational costs, religious programs, things like that. So you don't always have them, but they vary in that sense. But when you do have them, costs don't change a great deal. Now, the best way to understand this is the guidelines I'm going to tell you in a slightly inaccurate way how to look at these guidelines to help you better. The guidelines, if you look at each one as being 1/3 of the child support order, fixed being 1/3, variable the second, and controlled the last. The guidelines break it up a little differently. Like I think one is 28% and one is 37%, and then the last one is the balance. I think that it gets messy when you're trying to look at this from a common sense standpoint. So I always look at it as a third. And the reason I say that is if you have an exceptional cost that falls into one of these thirds, you may need to look to deviate from the guidelines. Now, when I opened the presentation, I said that they're presumed to be correct, but that doesn't mean that they're simply always correct. It's a rebuttable presumption, and I think a lot of people, judges and lawyers alike, fail to realize that. And if you have a high educational cost, or you have a special needs child, or someone with a special food allergy, you're going to have a significant deviation in one of these areas, your fixed, variable, or controlled costs. And you need to step aside from the guidelines and really take a look at that before just assuming that it's correct. Now, in addition to this, when they add the income, there are additional expenses that will be added into child support after the income calculation is done. So let's look at what gets added in. First is child care expenses, the net cost after tax credits of work-related child care. And it's an important distinction. There are a lot of issues that come up when it's work-related. Now, first of all, that it will be added in on a pro rata basis, which means it gets added in and divided proportionate to your income. A lot of issues arise, especially up in this area, with healthcare, with childcare, because of the cost. The exceptional cost creates a lot of issues for families. It's very expensive, and especially if you have several children at different age groups, because you may have one that has to go to pre-care, and you have one in aftercare and one in daycare, so you have 3 different payments. And I say work-related because there are a lot of issues that come up to whether or not it is work-related, like if you're searching for a job but you're not actually employed, do you need to have daycare? Now, some say yes, because you need to have the freedom to search for jobs and go to interviews. And others say no, you're not working, it's not work-related. There's also the issue of many people will have nannies and housekeepers as a sort of babysitter because it's significantly less expensive than a daycare would be. But again, it's not work-related childcare. That's a nanny. But the flip side often is it's not worth that argument because it's a lot less expensive. So you have to look at what's going to be the most practical in your situation with regard to whether or not you're looking at work-related daycare to add into your guideline calculation. Some more additions. Health insurance, the marginal cost of adding a child to health insurance. What that means is if you have a monthly health care cost from your employer that costs you $100, if you were just a single member plan with no family, and the added family plan, it was $150 a month. The $50 would be added into the guideline calculation, not the $150. So it's important to know how much that is. It's also important, depending on which side you are, to make sure that it's not getting inflated or you're getting undercredited for the proper amount. So you usually want to find that out before you go into court on this issue. There's also other things you want to look at. Some companies may have flex plans where individuals are actually putting money into a savings plan, which is going to medical expenses. That could possibly be used in the calculation as an expense. It could also be part of the $250 of unreimbursed can come from there. But flex plans are a little complicated when it comes to child support and figure out what they are. So if you have one, you just want to make sure that you know how it's going to be treated before it goes into or out of the child support calculation. Now, adjustments to child support. One thing, and the first one talks about it gets adjustment if you start child support for a child is 21 or older. Usually this is like a college issue. I think it could even be a little bit younger, like 14, 15, 16 years old. The reason is, and the calculations are usually done by a computer program. So if you have these numbers, it's usually just checking the box. The guidelines were created contemplating a lifetime of child support for a child, meaning from birth to emancipation. So if you have an intact family and they divorce when a child is 13, child support is going to be skewed because the way the guidelines contemplated this lifetime child support was that the child support is higher in the beginning because the costs of an infant usually much higher in many ways than the cost of a teenager. And I know a lot of parents here that are going to disagree with me, but if you think back, so they front-loaded child support calculations for an infant, and then it evens out and reduces later. So if you come in at 10, 12, 14 years old for child support, you're getting the tail end of that lifetime, and you're getting less. And again, this is a point that most people don't think about, and you really need to bring up the issue that it may be important to address and get an addition or some kind of adjustment for it. Second is legal dependence of either parent. This is called an alternate dependent deduction. If you have children of other marriages or other relationships that you're supporting, either with or without a court order, there will be an adjustment. Just quickly, I'll explain. You run a hypothetical child support guideline amount for that other family, if that family were to have a child support order. And then that child support amount gets added into the guideline amount, and then there's an adjustment for it. In many cases, I actually recommend my clients not to even seek an alternate dependent deduction, because not only does it greatly complicate running the child support amount, but the other parent's income becomes relevant to the initial child support guideline, and a lot of people don't want that. Sometimes it increases income in a way that you don't want done. So if there are other children involved, again, depending on which side of the case that you're involved, you need to determine whether or not the alternate dependent adjustment is going to be helpful or hurtful before actually seeking it. All right, more adjustments, multiple family obligations, similar to legal dependence of other families. Now, my notes here, my research indicated that the intention is to try to average if a family or an individual has multiple family obligations, multiple child support obligations. They can either average all the orders or adjust older ones to make them more commensurate with what they currently should be. In my practice, I've never seen them do that. Unfortunately, it's sort of a first come, first served. The person who gets there has a higher amount because the subsequent child support orders are required to account and adjust for that court order child support obligation. So if dad A has one child with mom A and then has a child with mom B's child support calculation will have an adjustment, a reduction in income for dad A for the amount that he's paying to the first mother. And I've never seen a court go and adjust it because the first parent has no notice, not part of the second child support hearing. So I've never seen it adjusted. If you're going to be involved in a situation where there are multiple family involved, multiple orders or children, know in advance how it's going to be handled and know in advance how you want to handle the adjustment. The last adjustment would be for government benefits to the children. We'll go right into this. There's means-tested benefits, which is based on an income need, rent assistance, subsidies, things like that, food stamps. When it's not considered income, so in a child support guideline, which we'll go into a little bit later, you would not be adding these into the guideline calculations. Then we have derivative benefits. These are based on eligibility standards from contribution like Social Security, retirement, VA benefits. These are counted in weekly income or counted as income for child support purposes. I truthfully don't understand why. I've always felt that they kind of have it backwards, that if you're getting needs-based support like food stamps, it's increasing your income because it's supplementing things that you don't have to buy with your income, where Social Security, retirement, and VA benefits you're getting because of work that you've already done and put it into. But I don't make the rules, so you just want to remember means tested are not included. Derivative benefits are included. Then there's other benefits, Social Security benefits, retirement plans, things like that, non-party. They too are not considered because they're not they are considered because they're not needs or means-based. Let's move right into shared parenting. The amount of parenting time is another adjustment that is made for child support, along with the health care and other adjustments that we talked about. And this is based on having 2 or more overnights per week in a given year, and it has to be by an agreement. It doesn't mean shared equal parenting time. It's called shared parenting when you have 2 or more overnights per week. Your typical alternating overnight weekend schedule is not shared parenting when you actually add it up, unless it starts early like Thursday or Friday. The intention when they created the adjustment for shared parenting was they believe that there's a sort of shift in the controlled and variable expenses that each parent incurs by having either more overnights when they have the children, or by the custodial parent having less. I don't know necessarily how much that really is true, because now, again, because everybody acts like the guidelines are accurate, when they have a parenting schedule, they don't realize that they should be shifting possibly more of their responsibilities. So, but going back to the shared parenting, let's take a look at some of the requirements for it. You need to file a parenting plan with a court. Now, in divorces, that's usually a requirement. It should also be with child support cases, but I don't see courts often requiring it. It's certainly good if you have one, but it's not often required. And these situations, if you file a parenting plan, it gives the court a little more discretion to deviate from the guidelines. And again, it's because there's a belief that you're going to be sharing more expenses. You may even have more, like the non-custodial parent may have increased expenses, like paying for more extracurricular activities, especially if you have more than 2 overnights. You may have a weekday overnight, you may have a 3 and 4 schedule, which is a little more of an equal parenting, but with shared parenting. So you might be taking the children to extracurricular, you might be enrolling them in events when you have them, you're going to be doing more driving because you have them longer. So there's going to be an adjustment because the intention is that the non-custodial parents sort of picking up more of the expenses than they would in a sole parenting or a less than 2 overnights per week schedule. And I say that because sole and shared confuses a lot of people. It doesn't mean equal, and it doesn't mean only. It just means different degrees of sharing. So let's look at income for child support purposes. Like I said, the guidelines are a net income, but we have to look at how is that actually defined. Net income is gross income minus mandatory union dues, mandatory retirement, and prior child support orders. Now, obviously, there's going to be more, but I try to take it in snippets for you. The term mandatory is very important because union dues are usually mandatory, but they're not necessarily. Retirement benefits are most often discretionary, but a lot of times mandatory. If you have these issues, you need to find out before you go into court if they are mandatory. If you're on the receiving side of child support and the other person's looking for an adjustment, you need to have them confirm that they are in fact mandatory. And these confirmations that I'm going to mention now and towards the rest of this webinar don't necessarily need to be done that day, because they're often not going to be. You're going to come into court and they're going to have 3 pay stubs and they're going to run child support. But there's nothing that stops you from saying to the judge that they should be required to provide proof subsequently, within 7 days, that the adjustment that they're seeking for the dues or retirement are in fact mandatory, and that they're not provided, that the adjustment is reversed and your guidelines adjusted. Don't think it's a one day in court and that's it. And also the other dependents, that becomes an issue once again. If people are seeking credits for the alternate dependent deduction or claiming they have a court-ordered child support, nothing wrong with seeking proof that it was done. And you want to go a little deeper and find out when it was entered, because I've had people try to run into court with a parent they get along with to get an inflated child support amount so that they later can be in court arguing that they need a lesser amount for the second family. So don't be afraid to dig into any alternate dependent or multiple family obligations. Sources of income. It's going to be a very long list, so I'm just going to take a second just to let you see these. I don't want to lose too much time. Very generous, so obviously compensation, operation of a business, gains in property. What's important here is gains in property is to go through tax returns if you get them, and you should get them, to see if there's a depreciation. Depreciation is a deduction that reduces the income that appears on a tax return, but it's not really an expense that they pay. So in child support, that will be backed out and their income be inflated again. Rents, which similar to business expenses, there's a lot more bonuses, alimony payments, annuities. Here, look for alimony payments. Don't forget, a lot of people don't realize that the alimony doesn't have to be paid to the person that's actually subject to this order. So if you have an alimony obligation to a different wife, that should be adjusted in your child support guidelines for the new family or for the new child support obligation. Moving along, there's some more. Distributions from government and retirement plans, personal injury awards, estate and trust matters, disability grants, profit sharing plans. I mean, these are all pretty much basic, but a lot of people don't consider them, and they would only show up in a tax return, which is, again, something you need to make sure you get, whether it's in or out of the initial hearing where the child support is going to be calculated. Lastly, workman's compensation, unemployment, over and part-time, and net gambling winnings. Interesting thing here is, well, there's a couple of things. Workman's comp and unemployment, things like that, and even before personal injury awards, are not considered income for IRS tax purposes, but they are for child support, which shows the intention of the guidelines to maximize the compensation or income available to support one's children. So when you're in court, you want to remember that, because if there is a question of income, which we'll see later through this webinar when issues like that arise, that you want to understand the purpose of the guidance to understand whether or not they apply to you. Now, with part-time and overtime also, the guidelines address that, because a lot of people have part-time or overtime that varies or vanishes, and some get it in the future. You want to usually look to the history. I believe the guidelines say if there's a 3-year history, for instance, for bonuses, then it's calculated into it. If people have overtime, it's generally going to be calculated into it. If the overtime disappears, you come back on a motion for modification. You can't even consider agreeing at the time child support set that if the overtime changes by a certain amount, it will be an automatic adjustment. It's always good to take these things into account, whether or not it's a contested matter or you're doing things by agreement, because the less trouble you have in the future, the more things you contemplate and work out, the better both of your lives will be. So if you know that your overtime will be decreasing, nothing wrong with bringing it up and seeing if you can agree to when and how it gets adjusted so you don't have to be fighting it in court. I got some more coming for you. Sale of investments, income tax credits, cash payments. That's interesting. They have cash payments if identifiable. That's rarely going to be an issue that comes up in court, because nobody's going to mention unreported cash payments. Judges don't even like it because they're required under a case called Sheridan that if they report, if there's any kind of testimony about tax evasion, they're required to notify the Internal Revenue Service. So most people try to stay away from the unreported cash issue, but if you believe there is, you want to figure out a way in advance to address that, so that you're not, or your child is not, shortchanged when it comes to getting child support calculated properly. Imputed income, which we'll go into in a moment a little more thoroughly, is increasing somebody's actual income if they are not working at their full capacity. And one of the ways you want to do this, again, going back to getting tax returns, is you might want to see what their past income was, if they changed the job, or if you had a child years ago and now they're at a different occupation or different employment. Most of the time, especially in non-divorce child support cases, you're not going to have a tax return exchange. And I don't even think the courts require it in most of those cases. But there's nothing wrong, again, with telling or asking the judge to order that tax returns be exchanged after child support was calculated, and setting at that hearing how much of a difference would allow you to review and modify the amount being ordered the day you're in court. Like, say, judge, give the tax return and tell them if there's a 10% or higher income in the past that I can come back and modify my child support. Or vice versa. Say, judge, you order the tax returns and then my income was lower, let me come back if it's 10%. Because sometimes people don't even know what their income history was. But certainly get it. Get the tax returns, because you're going to see things like business income. You're going to see depreciation, rents. These things are never going to show up in any other form, and they're not always going to tell you. Now, let's look at some things if you are not a guidelines case. The court is able, again, they're presumed to be correct, but that doesn't mean that they always are. So what does the court do? They look at certain factors when it's not covered by the court rules, which are going to be basically your custody factors, needs of the child, standard and economic circumstances of each parent. And then it gets a little more thorough, a little more interesting. They talk about the earning ability of parents, which is part of the imputation that we'll get to in a minute. They look at your history of training, education, and responsibilities for both this family and others, childcare responsibilities, um, and almost anything that would go into determining whether or not the guidelines and the incomes that are being applied are going to be accurate for this family involved. Additionally, they're going to look at needs and capacity of the child for education, including higher education. Obviously, that's college, which has been a very big issue. They look at the age and health of the child and each parent, and learn the income and assets of the child and each parent. For instance, you'll have children that might have 529 plans set up for college. They may have a trust from another relative. They might have gotten a personal injury award or Social Security benefits from a deceased parent. There's a lot of reasons these days why the child's going to have assets and income of his or her own. And it needs to be considered whether or not that's going to affect how the guidelines are governed, a non-guideline support amount. It also could bring you higher than $187,000 and take you outside of the guidelines in the first place. Of course, there are some more court-ordered support of both of either parent, responsibilities, debts and liabilities, again, the child or the parent. Now, that's also important because when you talk about college and child support, which are two separate things. I did a webinar, I think it was last month, talked about college, because college support and child support are entirely different. You may have one and not the other. One may go up and not the other, or one goes down. They're unrelated. Well, they're not unrelated, but they're separate and apart. So if a child has school loans or they're working to put themselves through college, it's going to be something that the court needs to look at. And then the last, all other factors deemed relevant, which is a catch-all that you'll generally find in almost any statute that allows a court discretion for almost whatever they want to consider. Not widely used when it comes to child support, considering all the other factors that are already out there for in and outside of guideline cases. But it's still there in case there is some reason that you need to deviate that might not be covered by all of the ones that we've already shown. All right, so let's go to imputed income I've been talking about. When will a court impute income? So first, the factors we're going to look at is what would the earning capacity or history have been if the family remained intact? And what is the reason that there is a lower amount of income or a belief that somebody's underemployed? There's more to this. We'll get a little deeper. Look at other assets, because some are income generating assets. There also could be substantial valued assets that are not income producing. And that also could lead to part of the reason, not only income ability, but it could be some of the reason why they're not working full time if they're managing side properties or businesses. Age of children in the household, child care alternatives. These are some things. But now how it's done is based on, first, the basic standard, and that is if a person is voluntarily underemployed without just cause, under or unemployed without just cause. And that's a difficult standard because in my experience, courts don't really look first at the standard. You just say, well, they're not working or they're unemployed, and they just say, okay, well, we'll impute income. There are a lot of people who are unemployed for cause. They may have been out of the workforce because they were married. They may be injured. They may be going back for a skill. You need to first determine if it's voluntary and it's without just cause. And generally, that is not where most people start. They start with the priorities that are listed here. So first, they look at potential income and earning capacity, look at your background, and when they're not able to determine from background, like tax returns or past employment, they'll go to the New Jersey Department of Labor and match up statistics on similar employments. And now that becomes tricky because the DOL will usually give you a range, high, low, and a median. And then it becomes an issue of the courts generally will take the median, which, depending on where you stand on the case, may or may not be the right way to do it. You could have somebody highly skilled or experienced in their profession. They might end up being in a higher area. They could be in a geographical area that compensates higher, like North Jersey compared to South Jersey salaries. So just going to the DOL mean is not going to be sufficient. So, but they will look at the basic one, and they will usually impute a minimal of income, imputation income of 40 hours at minimum wage. And that's generally for the divorcing spouse that's been out of the job market for many years. And this goes back to what I said a moment ago, that you sometimes need to argue that imputation is not always the right thing. if somebody has been out of the workforce for 20 years because they were taking care of a family, well, that's not willfully underemployed without just cause. But they will routinely impute income, at least the minimum wage. Now, truth be told, if it is just a minimum wage imputation, you're talking like $20,000, depending on the other parent's income. Having a zero income in that situation may not make a huge difference because, again, child support is based on the proportionate share of both incomes combined. So if somebody's making $80,000 or $100,000 and the question is between the other parent being at zero or $20,000, you may not see a huge swing in the actual child support difference. And that may be one of the cases where instead you agree to a different calculation. You agree to exchange tax returns. You can even consider agreeing to when it gets modified. Just give the unemployed spouse zero imputation. Say in 2 years we're going to come back and we're going to impute it at $40,000. So they get a break for the first 2 years, and then you get an increase, a greater increase in a couple years. So there are always ways to deviate by agreement. So let's look at times where you have guidelines set and you need to modify. Change of circumstances. The lead case is Lepus versus Lepus. It basically states a material change of circumstances is necessary to warrant a child support modification. Other cases say it's a best interest analysis. It's sort of a combination of both. But generally it's going to be something more significant than a passage of time or a slight increase in income. So let's look at the common situations. Again, now, increase in cost of living. My research suggests that is a reason allowed by the guidelines, but in my experience, cost of living, even under their case law, is not necessarily a reason the courts will do it. If that's your sole reason for going in, you're not going to get it. But on the flip side, the courts, the courts are required, the probation department gives a cost of living adjustment every 2 or 3 years automatically. So if you're the receiver of child support, you always want to go through the probation department and through either wage or direct pay to probation, because you'll get the cost of living adjustments every 2 or 3 years, or you should, through the courts. If you're out of probation and you make a motion to get a cost of living adjustment, you probably will not. So I always recommend to the clients that are receiving child support to go through probation. Increase or decrease in the obligor's income, that's the person who's paying. And if a parent or child has a serious illness or disability. Let's look at a couple more. Loss of housing, moving, that if the other parent, the parent receiving, is living with another adult and their cost of living is adjusted significantly, the person receiving or the obligee becomes employed or is earning more money, increases, change in the tax laws. These, again, are all sort of combined to be what would be considered significant change of circumstances. There's a couple more. Benefits of retiring parents, impact of reduced child support on other families. Essentially, these are examples, but each of them still needs to meet the material and substantial change. So when you look at an increase in income of the obligor, the paying spouses, as a change of circumstances, you have to determine what is going to be considered material and substantial. Is a 10% increase material and substantial? Is it 20%? It's case by case. Some judges say 8 or 10 is not, but 20 is. Others would say 10 is if you're making a substantial amount of money. It makes a very big difference. Moving along into cost of living adjustments here, this is just a site for explanations of how the cost of living is automatically adjusted, but it's usually going to be about 3%. But again, that's an automatic adjustment. It's not for changing of the income or for any of the significant ones that we talked about. Let's look at education and how that impacts the guidelines for a little bit. Tuition for children and educational costs are not included in child support. They are presumed, and what that really means is they are presumed to be paid for by receiving child support, which may be hard to grasp. And so I'm going to step back to the very beginning when we talked about unreimbursed medical care of $250. Theoretically, that's saying that health care is being paid for by having child support. So all that's not covered is the $250. So here, they're presuming that the costs that you incur to have a child educated, and this is not college, is included already in the child support you're receiving. So if you want to pay for private school or you have other costs associated with, you do not get an adjustment for child support. You pay it out of pocket. I think this is another area that really needs to be changed. I think the increased cost of education, not only in private school education, but even public school education, where children now are using laptops and iPads more often, there's a significant cost. If you're going to put a child in a private school of any kind, whether it's a private kindergarten, public school, or a religious school, you should talk to the other. First of all, you're required to talk to the other parent before anyway. But from a child support standpoint, you want to make sure that they're involved in the choice of decisions. They don't need to agree to contribute. They may not even agree to contribute. But if they're aware of it, and if you can show that had you remained intact, that you probably would have made this decision together, court may impose that obligation. Again, going back to the very beginning, the guidelines are based on what an intact family would do now that they're apart. So if you have a spouse or a parent to your child who either sent another child to private school or went to private school as a child or has a high level of education, these are all reasons that you can go to a court and say that that parent should be required to contribute to educational costs, to a private school tuition, or to the costs that you have for even the public school, based on what would likely have happened if you were an intact family. Let's take a little bit of a look at college. This is Newberg versus Arrico, which is the lead case on college. Obviously, college has been a significant issue in the news recently with the child who sued her parents for college, even though she was together. The basic issue in that, I'll just take a second, is if you are married, the court or the state cannot make you send your child to college. But if you get divorced, the state can make you pay for college. So there's a fundamental unfairness that's slowly creeping out to be addressed. But for right now, the law states there's 12 factors that a court's to consider when awarding college contribution. And remember, college is separate and apart from child support. So getting one doesn't mean you don't get the other or that it changes the other, although it usually will affect it. And again, one of these main factors, they'll go through the basic factors like they always do about the combined education and experience of the parents. But again, the first one is if they were intact, would they have contributed towards the higher education? And then again, you go to the history of the family, the history and education of the parents. You also want to look to the amount of contribution sought to the cost of the education. Because they want to look to make sure there's a relationship between the contribution and the kind of school or course study selected. Obviously, there's going to be significant differences between in-state and out-of-state schools. So if you have a child going out-of-state for a very simple type of program that could be received in-state, you have issues. There's something called the Rutgers rule that people use loosely to say that a parent should only have to pay up to the point of what a Rutgers or a New Jersey educational college cost would be. That's not that prevalent yet, but it is something that's creeping around. Look at the ability to pay, the financial resources of both of the parents. The aptitude of the child for the requested education, that's important. A lot of people don't think to look at that, but if they're going for something that they're not really made out for, they haven't shown an interest in, and it's maybe a demanding or expensive program, maybe reasons to look at it. Financial resources of the child, whether there's trust or other income like we talked about for child support purposes, will also be looked at for college contribution. The ability of the child to earn during the school year, that's not usually a huge issue because there's not usually a great significant ability to earn. Usually can't work that much, and kids at college age are not usually generating large incomes that they're going to be providing more than just what their own ability or their own basic needs are going to be. Financial aid is generally always going to be ordered as a prerequisite to being ordered or compelled to contribute all grants, loans, and scholarships. And the relationship and long-range goals of the child, which is difficult because I would think, children at college age don't really have long-range goals necessarily. I mean, some do, but necessarily not all of them. So it's going to be hard to see if their program is even going to make sense for them. So when does it end? Termination and emancipation. Parents' responsibility terminates when a child is emancipated. Now, there are many reasons when that can occur. It's presumed in New Jersey to occur when a child is 18, married, or has a child. Now, I say presumed because in New Jersey, child support technically doesn't end on its own. You would have to go and file to terminate child support. I've seen recently some courts are actually sending notices out now when they know that a child is reaching emancipation age, usually 18, asking if the parent believes they should be emancipated or objects to emancipation. I've never actually seen them terminate or emancipate for lack of response, but I have seen them schedule hearings when there is a contested issue. So I'm not really sure where that issue is going because right now, as it stands, they're not going to on its own. Here's the lead case that talks about emancipation. It followed the Newberg case, which technically Newberg wasn't actually a college contribution case. It was a graduate school contribution case, but that's a whole other issue we're not going to get into. GAC versus GAC did enunciate when the issues would allow for emancipation. GAC was more of a college contribution case that talked about whether or not delaying asking for college would prevent you from actually getting it. But the case is very helpful for understanding when and why a court would terminate or would emancipate. Bishop is another case that talks about the sphere of influence. And this is very important because, as this case notes, it's a fact-sensitive issue, but the standard for emancipation is that the child is moved beyond the sphere of parental influence, which means the child is independent on his or her own. Now, one becomes an issue as to whether or not that is the case, whether or not the person is or is not on his or her own. But then it becomes a question of whether they should be. Like if you have a child that graduated from a four-year college and went back living with mom or dad. Mom or dad may not be entitled to get child support because that child should be out on his or her own and just isn't. Obviously, that's a very big issue now with the costs of higher education, compelling a lot of children to return home. But it's still a question of whether or not they should actually be. I'm going to move quickly. Keegan versus Keegan's another case that says if you stop being a full-time student, you may be considered emancipation. So you want to get transcripts, progress reports, report cards, and just to make sure that your child is full-time. I've seen cases where they emancipate, then they unemancipate. So at least, the child support stopping at the time when the child's not in college. One more quick issue is retroactive termination of child support. Now, the statute for child support states that child support cannot be retroactively applied, up or down. So if you wait 13 years to file for child support, you're not getting anything years back. If you knew that you were getting too much child support in the past, you're not getting it back. But emancipation is different. The cases have developed to say that emancipation is not a child support obligation. It's a termination of the obligation to have to pay child support. So if the obligation is found to have occurred at a point earlier in time, the emancipation has occurred earlier in time, then that triggers the adjustment. They say it's technically not a retroactive adjustment of child support, it's a retroactive emancipation. So, and that's a very common thing because a lot of people don't know when their children are done school. A lot of parents don't share that information because they want to keep child support moving along. Here's our contact information. I'll go to questions in a second, but in case you don't have our direct information, phone number, address, take a second to write it down. I'm sorry I did go over time a couple minutes, but I do still want to take any questions. Let me see if we have any. All right, so give me a second to open up the questions. And when you write questions, you don't have to worry. I don't believe anybody else sees anything that you type other than me. So you need not worry about, and I don't see that you've signed on, so nobody knows that you're here. All right, so let me jump down to some questions. I'm going to try to read out the questions. I'm sorry, I've seen some notes about the audio. I hope that got better throughout it because I didn't know. All right, so first question is, how do you deal with bonuses and a non-custodial parent living in a different state that has taxes higher than New Jersey? if there is a tax adjustment that needs to be made inside the child support guidelines, the guidelines will adjust for taxes on an average basis. So when you put in your income, the computer program that we all use, or we all use some form of it, will calculate what it believes the tax should be. So if you have a situation where taxes are different, you can go in and have them manually adjusted. So you just need to raise that issue to the judge or to the parties that you're talking to. Let's see, next question. Actually, that might be the only question. I'm just seeing notes now that there's some audio problems, so I apologize. Like, that's the reason I try to check in the beginning, because I'm not able to tell as we go through this. I did record it, so I will be able to email you copies if you want to review it. You can even just go through up to where the slides are and review from the parts that are just important to you that you may not have received. I'll give it another minute or two. Hopefully you can hear me. I apologize if you can't or you weren't able to at certain points, but I'll wait a couple minutes to see if there are any more questions. All right, I don't see any questions. I thank you all for coming and taking the time. I apologize for the audio issues. I will try to address it and make sure that the next one doesn't have these issues. I will try to get an email copy out to you of the audio. If I can't, I'll get you a link to it because it's sometimes too large to email. If you have an issue or a question that comes up that you didn't get to ask me tonight, you can certainly send me an email. My email is still up on the screen. And with that, I wish you all a good night. Thank you.